Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you see?
Good morning. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Wonderful to have all of you here today. Good morning. Happy Tuesday. Happy Tuesday. We have a fun day. Why do you think all the cases that we want to follow plead out? Why is that? Live 3 minutes early. Are you okay? Says Tom Water Troy. I can see your concern. I can see your concern, and it's justified. I'm normally not early, but we've got a couple options today. We might be hopping around, getting a taste, dipping our toes in a couple things. There's a big one in Karen Reed. I sort of want to see which direction it's going. We might not follow everything that happens there, but we might watch a little bit as that begins. We've got a little spicy one. Well, we've got a little bit of a sleeper trial. That's what we'll say. We've got a sleeper trial we might watch really quickly, just a few minutes to get to sort of ready our palate for the taste of court, which we're going to get today. Good morning. Good morning. Melissa says, I'm not sure I've ever seen you be early. That just means you were late, Melissa. I've been early, I think, at least once before in the last 2.5 years. All right. Good morning. Good morning. What does court taste like? Oh, it's delicious. It's nutritious, and it tastes like chicken greeners. That's how it is. All right. Sloth Life says, my message disappeared when I was first. Sloth Life, you were first, but it shows that you retracted your message. I'm gonna count it. That's it. Sloth Life, congratulations. First in chat today. We'll put you on the screen even. Because you were first in chat, we're going to punish you with internet ownership. You know the drill because you've done this before. You are, in fact, a repeat offender in this area. First in chat, once again, it's wonderful. We are going to add this to your permanent record, but as punishment for your eagerness, your over-exuberance, we're going to send it to internet ownership. See above. Where's above? Oh, no, please give it. Oh, whew. You're lucky I wasn't done gifting it to you, Sloth Life, because once it's bestowed, it's set in stone. Shoefly Danny, I realize you weren't first in chat, but under the rules of internet ownership, it is permitted to have the gifting of the internet occur one time per day or per live stream, and thus you are now the recipient, and you cannot regift. So I don't know if you planned on doing this. This is your first offense. You don't know what you're in for. It goes like this. Everyone who has a problem in any way that's connected to the internet was going to be calling you today. It's not a lot, but I mean, think of the people, how many people are on the internet. It's like maybe 20, right? So if 5% of them, you got like 2 people calling, right? That's about it. So no, that would be 10%. 5% is 1. Yeah, you're going to do fine. You're going to do fine. Oh, 20 million? Okay. You're screwed. You're screwed. So, Certified Danny, congratulations. You're the internet owner. Good luck. Good luck. Thanks for being here. All right. We're going to get started with maybe some birthday songs, and then we're going to kick into court. It's early for math. I know 10% is 2, 1% would be 5. I can do that. Some math in my head. She's like, sweet, I'm up for it. Wonderful. Thank you. And I love the name, too. All right. let's see. Do we have any birthdays to celebrate today? Do we have any that came in? If we don't, it's fine. We can just go ahead. It's a smaller group right now because we just went live a little early, and a lot of you weren't ready for that. I sort of trained you to start around 9:45-ish, 10-ish, and now here we are. You know, just before 9 when we started. So, all right, we're gonna. One more reason why I never want to win the internet. Yes, it'll happen. It'll happen. I'm not seeing any birthdays. Okay, 80s. We're going to sing to My Mom. We need a name. We need a name, 80s. That's the way this one works. It's National Pancake Day today. Let's see, I'm not hearing the buffer sound. Vera. Okay, we've got Vera. See. In the UK. Do you guys even have pancakes? I mean, like real flapjacks. Butter and maple syrup style. International Pancakes Day, not just national. I was always like a beans on toast guy over in the UK when I was there. The mods are in mod chat. Amber's like, I'm coming. Wait for Amber. We've got Vera, 80s Music Band's mom. So we're going to sing to at least one person. And let's give Amber just a second to put this together. What's going on today? We're going to jump around a little bit. We're probably going to poke our head in the Karen Reed trail just to see which direction that's headed, because it's sort of exploded lately. And it might implode entirely. And if that happens, we like to be there for it. But it's also Pound Cake Day. Huh. Who would have thunk? All right. There it is. Leona and Jade 902. And we have to add Vera. Oh, there it goes. Perfect. And Amber added Vera to it. Thank you, Josh and Amber, for your help on that one. Debbie, you've been out sick. Good to see you. I'm glad to have you back. Hopefully you're feeling better and continue the mend. All right, we're all going to sing to Jade, Vera, Katie Bug, and Leona. I have to sort of look at the two messages because you guys are working off different spreadsheets, I think. Katie Bug's dad. Does Katie Bug's dad have a... Need all these in the same message. You guys know how challenged I am in this area. Katie Bug's dad doesn't have a name, apparently. Is that... Happy Mardi Gras, Todd. Wonderful. No, my dad is next today. Sorry, says Katie Bug. Okay, so we're going to take Katie Bug Dag out, but we'll need a name for tomorrow. Okay, so it's going to be Jade, Vera, and Leona. There we go. Oh, perfect. Amber, you did it. Congratulations. Thanks for your wonderful help. All right, everyone stand up, take a deep breath, shoulders back, project your voice to the back room, blend your voice with your neighbors, warm up with me if you will. La 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 la. Sounds beautiful. All right, we're going to sing to Leona, Jade, 902, and Vera here. Extra high kicks today. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to Leona, Jade 902, and Vera. Happy birthday to you. Leona, Jade 902, and Vera, happy birthday. I realize there are a million places it could be, a million people you can celebrate with, but you've chosen to celebrate here with us. The privilege, the pleasure, the honor is all ours. Hopefully we can turn that in some small way back to you and make your day a little more specialer. We'll begin by gifting you a free stack of flapjacks, yes, pancakes, American style, served at Denny's, IHOP, Waffle House, Village Inn, McDonald's, Tammy Dunlap's house, Bob Evans, and Andy's Grill. all those establishments participating in the free pancakes on your birthday phenomenon, I guess we can call it. Jennifer's dropping it like it's hot. I see that there. That is hot. Wow. Avert your eyes. Avert your eyes. All right. Just got here. My daughter Adriana turns 14 today. We're going to sing to her. This is like the a cappella verse. Ready? Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Adriana, who turns 14. Happy birthday to you. Adriana, happy birthday. 14's a wonderful age to be, especially for your time in life. I would never want to be 14 other than when I was 14. And for you, they've coincided beautifully. Hopefully your day is absolutely fabulous. Happy birthday, Roman ADCC. You've got a wonderful daughter, I'm sure. And it's her birthday, so spoil her rotten. Redford just figured out what the peach means in chat with the high kicks. I think it has to do with twerking. All right, we're at the last verse. We're going to go ahead and do the drum solo. So everyone join with me on that one. Beautiful. I missed a couple, but you guys did phenomenally. So happy birthday, all. We've got a little tiny palate cleansing court watch before we are going to pop in on Karen Reed a little bit today and see what's up there. Because they're just getting started. But before we do that, we've got this little tiny, I like to think it's a little sleeper trial. You know, these sort of creep up on you, and you always wonder what's going to happen next. But here we go. Whoops. And I promptly just moved it away from where I needed it. Okay. There we go. Can you hear that? They're not saying anything yet. Turn that off. Turn that off. Turn this off. And this off. There we go. Hey, here's a guy. Welcome.
Sure, good afternoon in the Nisqually Jail. What is your name, please?
Ford. Hello, Ford.
Your Honor, I believe this may be Reginald Ford, who was booked in as John Doe.
Oh, I see. Thank you.
John Doe?
Sir, your true name is Reginald Ford? Sir, can you hear me?
No, it was Ford.
Okay. What is your date of birth? I'm sorry, I'm having a hard time hearing you.
13.
Okay.
I cut that out. Just know he mumbled right there. I have to cut it out again because the judge repeats it. He's trying to dox people, but I don't let that happen.
All right. So your true name is Reginald Dwayne Ford. Is that a yes?
Yeah.
Your date of birth is October.
Yeah.
All right. Thank you, sir. And it appears that you are before the court for arraignment under case number 25L000488. City of Lakewood has charged you by way of criminal complaint with making a false or misleading statement to a public servant. Ms. Capone, are you prepared to proceed with Mr. Ford's arraignment at this time?
Like giving him a fake name?
Your Honor, Mr. Ford and I spoke briefly, but didn't get through all of his rights. So if he would like the opportunity to speak with me again, I'm happy to entertain a breakout room, but I don't know that we're ready to proceed on arraignment.
All right. Mr. Ford, would you like an opportunity to speak with your attorney before going forward with your arraignment?
Sure.
Was that a yes?
Yeah.
All right. So we're going to go ahead and put you in a breakout room. You may need to ask the officer to assist you in getting into that breakout room so that you can speak privately with Ms. Capone.
Never mind.
You don't want to speak with your attorney?
No.
All right. So Ms. Capone, do you want to go ahead and proceed with your arraignment?
Well, Your Honor, because I didn't have the opportunity to speak with Mr. Ford about all of his rights, I can't test or say that he understands them, but we have received a copy of the complaint. We'll waive a formal reading. And I wouldn't be contesting probable cause for today's purposes. Again, without having gone through his rights, I don't know that I can say without his approval that we enter a not guilty plea, but that would be my request as an attorney. If the court would like to advise him on his rights, then I would have no objection to that.
Thank you. So, yeah, we're going to need to do an advice of rights. So, Mr. Ford, as somebody who's charged with a criminal offense, you have the following rights. You have the right to be represented by an attorney. If you're screened eligible, an attorney will be appointed for you. Otherwise, you will have to retain an attorney to represent you. You're presumed innocent of any charge until the charge is proven guilty beyond a reasonable doubt. You have a right to a speedy trial. If you're in jail, it's within 60 days of arraignment. If you're out of custody, it's within 90 days. You have a constitutional right to a jury trial unless you waive that right. You have the right to confront witnesses. You have the right to call witnesses on your own behalf, the right to testify on your own behalf. You also have the right to remain silent. You have the right to a fair trial before an impartial judge. You have the right to appeal any finding of guilty by a trial by jury or judge within 30 days of entry of judgment. If you plead guilty, all those rights are given up. If you're not a citizen of the United States, the conviction could result in deportation or exclusion or other negative immigration consequences. You do have the right to consult with an immigration attorney prior to proceeding. I'm going to indicate that for the record, all of these rights have been provided to Mr. Ford on the record. At this point in time, the court is going to enter a plea of not guilty for Mr. Ford. The court will waive formal reading of the charge, the criminal complaint charging him with one count of making a false or misleading statement to a public servant. The court will turn to Mr. Graham regarding a factual basis to support the charge.
Yes, Your Honor. Let me pull up my
Some of the best sleep he ever got was during his arraignment. Disqualification is the jail name. That's correct. I guess if you hold still long enough, the camera thinks you've gone to sleep. Maybe the computer goes to sleep.
Your Honor, on March 2nd, 2025, at approximately 14:15 hours, an individual known as referenced as John Doe was contacted at 15,004 Union Avenue Southwest, the McDonald's, after the store manager called police to report he was harassing customers. John Doe provided officers with a name and date of birth, did not return to any record. John Doe then provided a second date of birth and seemed to be confused about his age when asked. John Doe was taken into custody for providing false statements to a public servant without incident. During a search incident to arrest John Doe was found to be in possession of a used glass pipe, commonly used to ingest illegal narcotics. John Doe was transported to Nisqually Jail and booked, but has not yet been identified. That was as of the officer's report. The name he gave, I was just going to verify, was Isaiah Washington.
Ooh, so not Reginald Ford.
Go ahead.
I personally contacted, Your Honor, so I'm speaking for personal knowledge. I personally contacted Nisqually Jail to find out if they had identified John Doe, and they identified him as Reginald Ford with the date of birth of 10/13/94. I don't have anything beyond that, as I have informed the officer as of this morning that he has been identified for them to complete the full investigation and make certain that the individual who is somewhat in front of the court is the individual involved in this case, so on and so forth. But that's as far as I've been able to get with it thus far this morning.
Somewhat in front of this court.
Based upon that, the court will find that there is probable cause to support the charge of making a false or misleading statement to the public servant, and will find, based on that record, that the individual that was booked in as a John Doe by the arresting officers appears to be the individual who is present in court virtually from the Nisqually Jail. It has subsequently been identified as Reginald Dwayne Ford. Does the city wish to be heard regarding pretrial conditions of release?
Yes, Your Honor. Your Honor, making the assumption that he is Reginald Ford, I did pull his criminal history. I see a number of prior cases with warrant activity, all within the last, I would say within the last 10 years or so. He is currently pending 2 counts of assault third out of Snohomish Superior as well. Your Honor, the concern the city has is that Mr. Ford would be unlikely to return if released by this court, noting especially that he gave a false name to perhaps avoid police involvement or police identification. So we would ask that he be held at this time on $2,500 with no law violations.
Ms. Capone?
Your Honor, I'll start with asking that the court appoint counsel from my office going forward. I'd ask that Mr. Ford be released on his own recognizance today, as these are nonviolent offenses before the court, just allegations, and Mr. Ford is entitled to the presumption of innocence on those. Thank you.
Did we just lose the Nisqually jail? I'm sorry.
Yes, we did. Computer went to sleep.
Nope, now it's back.
Judge, you have to let him in. Steve says, oh, look, the obligatory monthly resurfacing.
And in the Nisqually jail, if we could get the camera turned back. Thank you.
Until next month. Here we go.
All
He's
right.
back.
So
everyone moved.
Court has reviewed the criminal history for Mr. Ford. The court does note that Mr. Ford did identify himself for the record by date of name and date of birth at the beginning of this hearing, although it was difficult to understand him at times. Court is going to appoint Ms. Capone's law firm based upon that record to represent Mr. Ford as his attorney of record in these matters. The court is not at all confident in the likelihood of Mr. Ford appearing for future hearings in this matter.
Eyes open.
Based on the review of his criminal history, as well as based on, frankly, some of his conduct today. The court is going to impose bail as requested by the city. The court will impose bail in the amount of $2,500, cash or bond.
It's the first person I've seen who's slept through their arraignment or pretended to.
Court will also note that the city will need to file an amended complaint listing out Mr. Ford's true name at their earliest convenience. Other conditions that the court will impose: Mr. Ford must appear on time for all scheduled court hearings, have no criminal law violations,
stay awake.
Update the court of any change of address, use only his true legal name and date of birth.
No more fake names.
Court will also note an out-of-custody pretrial conference date.
As far as disrespectful, this is probably on the low end of the spectrum. We've seen worse.
That'll be March 27th, 2025, at 1 o'clock in the afternoon, in the event that Mr. Ford is able to
wake up,
secure his release. And the court has signed that order. Mr. Ford, that concludes your hearing, sir. You can go ahead and let the officer know that you're done.
Oh, he's wide awake. He's wide awake. He's out of there. Okay, that's it. That was a sleeper trial. That's all we had for you. That was it. Sorry, that was funny. I found that one funny. Josh found that one for us. So thank you, Josh, for that wonderful little way to start off the morning. Let's jump over to Karen Reed. We're going to be a little bit behind, so we're going to play catch up as they get going, and we just want to get a feel for how things are going today. So let's see that one there. Okay, and let's back up. Just barely began just moments ago, as a matter of fact. Trying to get a little bit of ceiling fan for you so you get the feel of court.
All right, the court, please. Yay. All present have any business before the Honorable Beverly Cannoni. Justice of the Norfolk Superior Court for the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed. Can I please identify myself for the record?
Good morning, Your Honor. Laura Hoffman for the Commonwealth. Good morning, Mr. Bluffman.
Good
morning, Mr. Lally.
Good morning, Your Honor. Hank Running for the Commonwealth.
They're in 1.25 speed until we catch up in about 2 minutes.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Mr. Leslie.
And good morning, Your Honor. David Kennedy for Karen Reed.
Good morning, Mr. Nettie. Good morning, Mr. All right. So we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ARCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, or Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under dotted grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes at the Canton Police Station video.
That's a lot of motions.
So that's the order that makes sense to me to finish up what we already had scheduled last week, before we do anything else. So the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little? Yes. And Mr. Alessi?
Yes, Your Honor.
So, each attorney is legally accountable for the actions and statements of the entire team. So, now the questions that I have, Mr. Alessi, that you said welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you called it. Could you stand, please? Because I am going to address you.
Yes, I was going to go to the podium.
Sure, go ahead to the podium.
Thank you. I didn't want to stand while you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Renschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor. I do not know that as a fact.
Okay. So now my next question is, regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice.
And you're referring to the record of payment being...
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. on this was filed, I believe, on the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your question. I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned...
You don't have to repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to... So I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through, and when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was, right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis in construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world. I agree completely with Your Honor.
Okay, now I think we're caught up. Now we're on live speed here.
All right. I'm not going to ask other counsel. All right. So let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I marked them as exhibits. I didn't do that last time.
The white book?
The white book, and I had marked. Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1, so I picked off on 2 and worked it out before. What would you like me to do with these, Your Honor?
You can hand them to the court officer who will hand them to the...
Well, there you are. Thank you. Thank you, Your Honor.
This is defense.
And have you concluded what you...
Alessi is the newest lawyer on Karen Reed's team.
Yes, 229.
All right.
That was
let's
fiery.
go on to
What a start.
Did the Commonwealth want to add anything?
No, thank you, Your Honor.
All right. So let's go on and let's I don't have it here. Jim.
So he's saying we didn't know that we had
$4.99.
paid the bill.
So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I've read it. I read it 2 weeks ago when it came in, Mr. Leslie. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take
back
your
to
time.
Thank you.
Take your time. Wow. I didn't know they made iPads that big. That thing is ginormous. It's like an 18-inch iPad. Just balance it there on the bar. I'll just stick it back there in the gallery. Nope. I'll drop it on the floor. There we go.
Please, the court. The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert-Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements, so it's very clear that's the subject matter of his testimony. Your Honor stated, with regard to Dr. Rentschler, that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury, the key point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm, and yeah, you'd have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume, hypothetically, it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field.
This is like using a banana for scale,
He
basically.
provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study, he doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was, for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition.
It's a dog bite study.
And in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More important, WHO makes it clear that the only people that can do that are forensic odontologists. People that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound? 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in a defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine, but the fact is, her main point is he never accounted for that in his methodology. It's not an opinion, it's a methodology. So, it again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support. But he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling
this
and
dog bite thing's
pinching
gonna
and
wrap up
piercing
here
of skin,
shortly.
skin when there's any pressure, particularly with a bite.
There's some very
it
spicy
moves,
arguments
it dimples,
coming.
It hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So, with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about...
How many pages?
On page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is not one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities, a Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods in reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, etc., etc. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a
Here's a summary. This is a big finish.
He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close. and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the decedent.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Are you planning on bringing that in?
I wouldn't ask him to do that, no.
Okay. All right, so I'm hearing the motion.
Yeah?
Yes.
Mr. Releasy tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case. And so in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. That was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Releasy's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive. Variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Lisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he has, and I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the package? The exhibits that I have are attached to the Commonwealth's, the defendant's motion.
They have.
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in this package.
I think that's attached here. I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it has not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was Chief of Animal Care and Protective Services of the City of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate Canine Brain Project, 2023 to current. It's associated with Harvard University. Duties include the investigation and documentation of dog bite and related human fatalities. Also, Division Management Consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured the distance of all of those teeth specifically. And then in his methodology, he outlines each group of lesions specifically. Lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Alisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case he finds canine DNA. So he does look to alternative sources, and mindful there was pig DNA found, so it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA. And so while there are different methods, and some of the things that Attorney Alisi spoke about, dentition, deal with human biting, not dog biting, his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
Okay. All right, Mr. Alesi, any follow-up?
Thank you, Your Honor. Thank you.
if I permit it, they do not intend to call him.
The Commonwealth did not address in its presentation, you heard, one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it. But the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. It wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number 2. Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now...
Hold on, so that's Exhibit 1?
Yes, exactly.
Just give me a minute. Just put them back in. All right, so what page?
Every page. The point is, there's not one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay.
So he's got it in alphabetical order. Importantly, the page before, 1399, at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, He must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer-reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Daubert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Daubert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard. But what is it that he is participating in Harvard in? This was from the words of Mr. Brennan. Canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology.
Facts
so
are
I am
somewhat
still,
relevant.
after
That's a
all
funny
this
quote.
time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Okay, sit down. We're done. No more argument, please.
Briefly.
Briefly. Here come the points.
On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, It wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Alisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. If you look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter if somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
No specifics.
Okay. So before we move on to the next motion was, it was filed after the other motions that
this is the date change motion?
It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative, a Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, or you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Alessi, this is you again, right?
Okay. It is, Your Honor.
All right, so I'll hear you.
Alessi goes again. Next issue, asking for a Daubert for a Commonwealth expert. We have some spicy stuff coming up.
May it please the court.
Good.
Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil.
Weatherwatch was a golf pro. He knows all about soil conditions.
He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes.
It's the punctuation, Your Honor.
So his certified weather statement is hard as a rock I believe I'm looking for it.
So I'm sorry, there are a couple of exhibits attached to your affidavit, Mr. Alessi?
Yes.
All right, so one's Exhibit 1, I don't see any.
I'm sorry, Your Honor, it's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it now. All right. I don't see anything that says certified weather statement. It's an email, right?
No, his report is Exhibit 1. It does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes,
hey, Brandy,
which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather?
I need this.
We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, The whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Right.
Thank you. Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do. Case in chief.
All right, I'll hear you.
Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed, to talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours.
Please ask him more about the snowfall.
Will be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock, and state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Okay, would you say that, Mr. Lessons?
Are you done, Mr. Brennan?
Are you done with the podium? Like a
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned. But its proposal to have a meteorologist talk about how ground freezes is still very much problematic because, just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G., 2005, freeze-thaw effects on penetrometer resistance and shear strength of...
Why don't you put those in right now? Was that just a Google search? I saw that you had it on your...
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement.
So the judge says, is that just a Google search? Says, no, I consulted with God about how he designed the earth.
How long did each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, or the cases and the qualifications of Dr. Crosby.
I can have that to you today.
Great, okay. And those articles, Mr. Alessi, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
Would you like me to hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Leslie? Did co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out
Co-counsel only has
something here
Google.
that's-
Sure. You don't have to do it right now. Do it before you leave today.
I'll do it before I leave, Your
And
Honor.
that way
Thank you.
there, we'll see to it. Jim, can we get a copy made for everybody? Thank you.
Jim's going to be
All
at the
right,
copy machine
so
today.
now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. And this involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Sure. Okay.
All right, to the board,
Is
please.
the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, I'm going to see Council.
Maybe see.
So they sort of,
Quiet, please. Still on the record.
they're still on the record. The flash drive has been impounded. That means we're getting to some juicy stuff. We're listening to the white noise. Man, good stuff. So we get a little bit of a break. There are a couple things on this this hearing today that are going to be spicy, because one of them is the motion to change the date for a specific hearing that has to do with the late disclosure of video from the Commonwealth. And this is like new videos that just barely came out after the trial, Sallyport video, and data related to the Sallyport video. They make the motion, and they're like, hey, first of all, they say, hey, we've got a problem with, the state just giving us this stuff after the trial. And then after they made the motion, they get more. And they're like, wait, Judge, we can't hear that argument yet because now we have to go over the new stuff because there's new stuff coming out. So that's going to be spicy. But who would have ever guessed that the next trial is probably going to have a lot of testimony from a lot of people about whether it was snowing and the ground was cold. So that's going to be fun to hear. I can tell you that. All right. Let's see who's calling here. Oh, they hung up. Whoever it was, they're gone. Oh, man. Oh, they're back. It says call's ending. Hello. I think it was Mathis. It was a slow one. I can't see starting April 1st at this rate, especially if they're adding more Daubert hearings and everything to it. This is crazy. This is a lot of hearings leading up to it. It's going to be a packed schedule leading up to a retrial. What do you guys think of the beginning? The judge's, I would say she was quite angry and she wanted an explanation. She comes out and she says, just so you know, you guys are a team, and what one person does, all of you are accountable for. Which is, it sucks if you've got a bad player on your team, but if you've got a good team, it's great, right? It's like playing golf, and it's closest to the hole wins. If you're all good players, that's great. If you're playing the opposite, furthest from the hole wins, or furthest from the hole is where you have to play from in golf. Suddenly a bad player is very bad on your team. But she says, hey, you guys made this, you presented something to the court about your relationship with the ARCA guys and whether or not they were paid and everything else. And I want to know if you knew. And apparently he said we didn't know.
Call from Angela.
Angela, how are you doing?
I'm doing good. This was me earlier, but my phone was just not cooperating, so sorry about that.
No worries. What's up?
So, wow, for a hearing, and I mean, defense is on fire, and Commonwealth as well, being Commonwealth, Have you noticed, I don't know if you went through the document, but have you noticed the spelling mistake in Brennan's document?
I didn't. What was it?
Instead of writing prosecutor, he wrote prosecutor, which can seem innocent enough. Forgot a letter, but prosecutor is actually a word, and it is like a person that prepares body for dissection and in morgues and medical schools and.
So not the word he
yeah.
probably should have used. The prosector.
Yeah.
Yeah. Oops. Spell check. That's the problem. Spell check won't catch it because it is a word. You need to use AI to make sure it makes sense. Oh, that's funny.
That's why there is like the human spell check as well, another peer review. But speaking of peer review, what's bothering me is that Hank Brennan went on Dr. Russell about whether or not she's peer reviewed, how many articles she wrote, and so on and so forth. Mm-hmm. So I finally found the Jane. I was like, okay, let's find the guy on the Commonwealth is calling, and I could not find a single thing that he wrote that Brennan mentioned. So I went to the library and asked the librarian to help me find this guy. Found him in the databases that I have access to through the library. While Dr. Russell took me 5 minutes, even less, to find her and what she wrote and published in all of the databases that I have access to. I had to go to a separate database to find Crosby, while took me 5 minutes to find Dr. Russell.
Yeah.
It's insane.
But is that really put any weight on how valid it is, or is it just one's just more well renowned?
I mean, the only article he wrote is the PhD one that Alessi mentioned. While Dr. Russell, she has written several ones. I don't know if I didn't look for her while she was in med school articles, but the ones that she published afterwards, she has several ones. But I don't think that the matter. I think what Alessi said is that she has like experience, and she wrote based on what she saw, and she has like evidence to prove what she has something to back her up what she wrote in her report, while Alessi did not. Crosby did not. He assumptions and just believe me, like Trooper Paul. It just happened. The dog spoke to me.
Dog spoke to me.
Yeah.
Interesting.
Well, he didn't say that, but basically he did.
Yeah. I don't know. First of all, we're not going to get answers on these questions today, whether or not the judge is going to allow it or not. She rarely rules from the bench, right? It's always a written, she'll take it under advisement. A week or two later, we're going to hear something from the court. But some of these decisions need to be made soon, because they're going to affect how trial proceeds. And we're coming, a month away. That's crazy. We're a month away from the retrial. So.
Even less. It's like, 3 weeks and counting?
I thought it was early April, right? Or does it start at the end of March?
April 1st.
Yeah. So yeah, a little under a month.
But, and also, is she seriously thinking of reprimanding the defense when that mistake, if you can call it a mistake, was minuscule, and can in comparison to what Commonwealth did, didn't they provide certificate of compliance that they gave the defense everything, and then they're still turning over stuff?
Yeah, I don't know. It seems from like an impartial standpoint, I try to not have a dog in this fight. I'm not like Team Karen or Team Commonwealth. But it seems like
I'm Team Science.
You're Team Science. I'm Team Facts, right? Facts are not as necessarily important as the process. I need that quote. I didn't grab it. I'll play some of the quotes I got if I got the good ones. But anyway, good thoughts. I'll have to think it over. I know Mathis is harping on me. He wants me to talk about the disciplinary rule 7-109A. So,
yes.
So we'll
I'll
cover that
hang
quickly.
up and yes, talk to you later. Bye.
Angela, thank you. We'll see you. Bye.
Thank
Oh, I didn't mean to hang up on you there. Mathis says, remind RA about the super chat. When you have time, please look at Massachusetts Disciplinary Rule 7109C and compare and contrast using APA format on a 10-page double-spaced. No, just kidding. Here's what I'll read. Rule 7-109C. This is what the judge came in spitting fire about initially, right? You can watch the court. Nothing's going to happen there. So, a lawyer shall not pay, offer to pay, or acquiesce in the payment of compensation to a witness contingent upon the content of his testimony and the outcome of the case. But a lawyer may advance, guarantee, or acquiesce in the payment of expenses reasonably incurred by a witness in attending or testifying, reasonable compensation to a witness for his loss of time in attending or testifying, reasonable fee for the professional services of an expert witness. The imprecise wording of this disciplinary rule 7-109C and the divergent opinions of ethics committees discussed below reflect several policy considerations. It is clear that the courts are entitled to every person's testimony, whether the witness is compensated or not, and that giving or accepting payment in order to testify a certain way is unethical and may be criminal. On the other hand, it is acceptable to compensate for their preparation and testimony a wide variety of experts. Moreover, government witnesses such as policemen frequently draw overtime for court appearances and are often paid for time spent testifying. Let's see, you wanted parts 1, 2, and 3. It has to do with just the payment of experts. And let's see, that's ethics opinions. This is from the Mass Bars where I'm getting this. Informal opinions. You can't pay someone based on how they testify. Rules of professional conduct. Let me turn this down. That's too loud. Rules of professional conduct. Yeah. Mathis, that's probably deeper than most of us want to go into the analysis on this one. We're just going to let it play out. Tag member for 26 months. I need him to argue my electric bill down. Yes, Mr. Lessie is good at arguing. Simply Nikki gifted 1 membership. Thank you very much, Simply Nikki. Selena K, thanks for checking in. Still in a lot of pain, but hopefully we can help distract you a little bit through the recovery process. Sandy Graham, member for 5 months, says, missed y'all. Welcome back to the gallery. Thank you. Steve N, member for 17 months this morning, says, oh, look, the obligatory monthly resurfacing and sending of the milestone chat until next month. And then we had Katie Bug earlier during our sleeper trial with a super sticker and super chat. Thank you both. Britt Bottoms, member for 13 months, says, nowhere else I would rather be. Member of the jury. Britt Bottoms, thank you very much. Appreciate your support. And Mathis says, the point is defense paid under 1, 2, but not 3. They did pay, but you heard the knowing thing? He basically said, I didn't know. We paid and I didn't know. I heard that was the argument. We'll see what the judge does when she rules on that one. The issue isn't the payment. Of course, experts are compensated. It's the fact that it wasn't declared. Yeah, it was paid, but he didn't know it was paid. And honestly, I think it looks really bad on the defense. I think if we're being 100% impartial looking at this, I think that whole situation is a little shady and dirty. Just like we can look at a lot of what the Commonwealth's done and said, that's shady and dirty. I think that was, tit for tat, sort of. Bev will spin it to fit the Commonwealth's narrative. The case will end up in SCOTUS. Mark my word, says Sinbad. So when Brennan says he didn't know about all the video footage, you have to give him the same grace. Lizzie, that's the argument. I didn't know. But the problem is the law is a little different when it comes to these facts. It's not the same law. I think in the two situations, if you were to rank them on their severity, I think the court would generally look at the violations of discovery as a bigger issue than the payment of a witness. I think it has to do with the defendant's right to have access to stuff, and whereas the court has rules about things, but I don't think the payment rises to the same level as the discovery issues. Does cut both ways. I agree. It does. And, in football, American football, when two teams are, battling it out on the gridiron, one team might grab somebody by the face mask and tackle him. The other guy from the other team grabs somebody in a horse collar and tackles him. And you have two offsetting penalties. I'm wondering if the court will say, hey, you both did bad. Now, recognize they were both bad, but they're offsetting and move forward. Keep going. I'm not sure if she'll do that or if both get sanctions of some sort. So the AJ hammered in the first trial. They didn't hire them, which they didn't, but they paid them. So, yeah, that whole thing is it did look bad. While you're checking the rules, check tampering with evidence. It's a great read. Good morning, Anne-Marie. Thanks for checking in from Canada. Good to have you here. I'm at a loss as to what the discovery violation is supposed to be for the forthcoming trial. Teresa, there were videos and metadata regarding videos and chain of custody documentation and things like that related to videos, all associated with the Sally Port, that the police garage where Karen's car was taken. Because the issue in this case has really sort of revolved around the taillight and whether it was broken, how much it was broken, when it was broken, where it was broken, all those issues. The defense has said that moment that their car is first towed from her house into the Sally Port, it should have video of her car being pulled in. And in what they say is a remarkable coincidence, all the cameras are either obscured, blurred, or just plain missing that little clip. And so there was some video from the Sally Port that was presented. Some was presented during trial, during the last one. It was inverted. That was an issue. There was some that was very blurry. That was an issue. And now there's more video that has come out. Maybe not. I don't think any one part of it would be exculpatory in and of itself. Saying, "Hey, look, as her car was pulled into the Sally Port, the taillight was 100% intact. There was nothing wrong with it." I don't think they don't have that. Okay, it's not going to be the mic drop moment, but the fact that that was loud. Bars and tone. It's always good to send that. The car did not hit John, and John was not hit by the car. Full stop. Science doesn't lie, says Tash. Tash, here's what I will concede, and I realize I'm probably in the very small minority because both sides are not happy with where I stand on this case. But I definitely will say I don't think it happened the way the Commonwealth says it happened. That doesn't make sense. You can't math that situation into existence. Okay, and math, you can't do that considering all the variables. It does not add up, and that's a problem for the Commonwealth. I think if they were more vague in some of their accounting for how things went down, it might be more possible in my mind, but the way they've told the story in the first trial, I can't see it happening. I just take the taillight out of the picture. There's the car, the strike, the body position, the spinning, the where evidence ended up. It just doesn't. Yeah, physics ain't physicking. Physicsing. I think there's an extra S in there. This is a test of the National Weather Service. Speaking of which, I know the Texas area down south had some rough weather last night. Weather Watch let me know. I think it's coming my way tomorrow. So apparently it didn't lose all its energy and spin out tornadoes in the Central Plains area, and it's coming my way. So that'll be a little scary. Let's see. There's reasonable doubt. Reasonable doubt is all Karen needs. As long as the jury understands their job, I would say yes. All she needs is reasonable doubt. I think too many juries are trying to solve the case. I think at the Ferris trial, you don't always need to explain exactly how it happened. Britt Bottom says, Texan here, all is good, but there's significant damage all over. Hopefully no lives or property damage that's too severe. Is this going to be all day? I don't know. Usually it's not. Usually it ends abruptly, short of when they scheduled it. Sherry says, yes, we were under a tornado watch until 5 this morning. The scary thing is it happened at night. And as Thomas would tell you, our local meteorologist, who does not do ground hardness measurements, the nighttime ones are scary because you can't see them coming. And a lot of tornado watch and warnings is that ground's truth factor of what you can observe on the ground. Storms later. NOLA parade started at 6 a.m. to beat the storm down there in Mardi Gras. Aaron Blackman says, all right, there's no way to have Trooper Proctor guy testify again in the second trial, right? I would be so embarrassed if I was in his position. That would be a huge black eye on the prosecution. They've got to get around that. But how can you just cut him out of the whole trial? Because the state could basically drag him in and drag him through the mud. Too many people with strong feelings. I do believe that this is one of the cases where we need to take a deep breath, and I think there are some times where we need to just stop talking about it. Okay, I realize this is important, but there are some environments where the discussions and the circus that's gone around this case, we reach a point where attempting to communicate in some environments is not fruitful. It's not beneficial, and all it does is rile things up. So just know where that limit is. Don't let it get to you. Confirmed tornado in Shreveport, Louisiana. Ooh. Hopefully that's not right now. If it is, please stay safe. 60 to 70 mile per hour winds here in Colorado Springs. Lizzie says, I'll be honest and hate me for it. I understand reasonable doubt. I do see its merit in this case, but I see enough to find her guilty of DUI and manslaughter, negligent homicide. That's awesome, Lizzie. I don't fault you for that at all. I think if you're looking at the evidence and you can reach that point, reasonable minds can disagree, and so I'm not saying it's impossible for somebody to look at that and reach that conclusion. High winds warning in Kansas, storms and tornadoes in Oklahoma and Arkansas today. Bad, supposed to hit here in 30 minutes. Giving my pupper his chill gummies. Susie, please stay safe. Obviously, keep an eye on the weather. Ryan Holyall is a great channel for that. There are some others as well, but I like Ryan Holyall because he's most of all the channels. He's got the most tech, and that's what I like. I like the tech side. Seeing behind the scenes of his studio is amazing. If the Commonwealth doesn't call Proctor, I would think the defense would call him. I think so as well. So we're waiting for the other judge's ruling, correct? Yes, we are. The other judge we're talking about here, we know that the two sides in the the corn rake trial that we just finished up yesterday, or the civil hearing we finished up yesterday. The two sides have 30 days to file like a brief, a 5-page brief to summarize their documents, their position, and provide some, mostly case law, I think is what the judge is looking for, that she can base her decision on. So nothing's going to happen before that 30 days. It's possible the judge during that 30 days could read everything else, but it's also more likely that the judge will sort of read what she thinks is necessary and then wait for those documents, read those documents, and go back and read anything that might become more pertinent related to that, and then rule. So at least a month, possibly as much as 2, I think, before we hear on the corn rake trial. Let's see. We do have a Lego build. Legos are supposed to arrive today, as are my 8 bottles of Sticker Mule sauce, hot sauce. I ordered 8 bottles of it. The first bottle was delicious, and I think I need 8 more. Maybe I'll send some out to somebody. It's good. It's like a sweet Tabasco. Let's see. Amber, send me the link for the map. There it is. Let me find that over here on this one. Take that. We have not been counting anything today in this trial, although we probably should have counted not the train, but the police. Number of times the police sirens went off. I think police and horn honking should be great. Not corn honking, horn honking. Too many farming trials. All right, here we go. Quick view of this right here. This is our map of viewers, by the way. If you haven't put yourself on the map, you should. It's wonderful. Let's see. We're looking. Let's zoom in. That's too many of us. All right. So this area of Texas is and sort of going up at a right angle, sort of at 30, 40 degrees or something like that, is where all the storms are coming. I'm on the East Coast in North Carolina, which puts me right about here. I think that's me. Is that me? I can't even see it. Nope, that's somebody else. Stephen Sitches with Kristen. She's nearby. Yeah, I'm right there in that area. So, do you still keep in contact with Zachariah Anderson's brother, Solomon? His website has gone kind of silent. Did they just accept fate? I don't think so. I think they must be close to filing the appeal, right? I've not followed. I have not kept in contact. I've run into him on some other channels. I know Valhalla awaits, MLS Law. I've seen him in chat over there, so I've seen him online. I don't know. I don't know where they're at on that one. Okay. Let's go back to here. This way. I want more ceiling fan. There. Now the ceiling fan's above me. That's better. Keeping me cool. I'm on the list, but not on the map. Lisa, the way the map works is, how do you put yourselves on the map? That's a great question, first of all. Amber's going to post this comment here again in chat in just a second. The first link, this one on top, that's when you click on to submit your information. Don't give us your exact address. We don't need to know that. Just your general area. The second link is where you can view all of the pins. And if there is somebody else who's already posted a pin in your city, only one person is going to show up, but you can go in the search field on the left-hand side and search for any name in chat, and if they've posted it, you'll see the general area where they're at. It's always fun to see where people are at. Emily D. Baker is fantastic, one of the pillars of LawTube. She has some of the great sayings. Can't put the poop back in the horse is one of my favorites from her. I'm back. What are we watching? The Ceiling Fan right now. We're taking a peek at the Karen Reed motions that are happening today because I think some of them are spicy and some of them could be quite interesting. I want to see how the state wiggles out of some things, some situations. Newcastle, England. Nobody can point that on a map, says David Reed. We might. I think we have somebody over in Newcastle. Let's see. Let's go across the pond over here. I have to zoom in so I can see because my geography is terrible. Okay, Manchester, Liverpool, Sheffield, Northampton, Birmingham, Stoke-on-Trent. Where's Newcastle? Norwich. Been there. Oh, we're back in court. Sorry. Coming back right now.
Great. I want to thank you both for getting me these materials, Mr. Wilson and Mr. Murray. Thank you both. All right. So the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Road Criminal Procedure 48.
So the Commonwealth goes first on this one.
Did you need a minute or so?
Could I please just...
Sure.
Thank you.
Timmy?
Yes, I'm working on something.
What's wrong with Mr. Alessi?
Why don't I take a 5 minutes?
All rise, please.
What happened with Mr. Alessi? We just took a 20-minute break, and Mr. Alessi just said, I need a minute. The judge called out to one of the bailiffs. Judge calls out to one of the bailiffs, and it says, let's take another 5 minutes. There we go. We get another 5. Commonwealth wants sanctions. I think they've both asked for sanctions in one way or another. The sanctions are delaying the sanctions hearing. I thought it was Dinetti, not Alessi. I know it ended with an I. I can go back and replay. Hang on one second. Let's see what she said there. You ready? This is a quick little replay here. I think it's on 3. To make sure the mic's coming in right. Why do I not have a dual viewer? I'm just going to play it so you can hear it. Sorry.
Most motion to impose sanctions pursuant to Mass Road Criminal Procedure 48. Mr. Alessi, do you need a minute?
Mr. Alessi.
Did you need a minute or so?
Could I please just...
Sure.
Thank you.
Timmy?
Yes, I'm working on something.
That's weird. So, Mr. Alessi, do you need a minute? Timmy, and then the judge's eyes are going back and forth. I don't know why this is not playing right for me. Let's restart it. See if that fixes everything. Always helps turn it off and on again. Timmy was busy. He's like, yeah, I'm working on something. Can't you see I'm busy here?
Back in session, you may see.
Thank you for that.
Sure.
Now we're back.
All right. So,
everything's better.
Brennan, I will hear you on this motion.
Thank you. As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials were just some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watch other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court, it's unfair to the people of the Commonwealth, it's unfair to the Commonwealth, it's unfair to the prospective jurors. And so, not only is there not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We turned it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57, and again, there was a protective order, and then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so, the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements, and despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is...
Where was that court TV appearance?
I can get the date for Your Honor. Recently,
hang on
February
bring an
18th,
allegation and don't
when
have a
we were
date.
arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, The Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any
All
objections if
pleadings
there's
under
any
seal?
material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also,
That's
the
the sanction
Commonwealth
he wants.
suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does.
That's the sanction?
No more symposiums on the courthouse stairs. No more interviews with national media.
That's a gag order, basically.
No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact.
He's asking for a gag order.
There should be a gag order on all of these attorneys, every single one of them. And the Commonwealth will not speak either. Ms. Reed, I'm not asking for a gag order for. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves,
it's a big ask.
In light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions, and that's what I'm asking for. Thank you.
Mr. Nettie, you're arguing this, you said?
Yes, Your Honor. Here comes the response. Buckle up. Here we go. Quick sidebar. He wants to gag order the attorneys, but please, by all means, let the defendant speak. Well, if she talks, she might say something that might be beneficial for the prosecution. I don't know how you can EDB's, toothpaste back in the tube, poop back in the horse. How do you start a gag order 1 month before trial? Seriously, what is that going to be effective? I think it might be their big win would be during trial, to have a gag order during trial. Most information is already out there. Do have a sidebar. Okay, so just so you know, I did get packages. My son brought them in. The Lego box I ordered, the set I wanted to do, is huge. I think I've made a mistake. It's the biggest Lego box I've ever seen. I can't show you because it'd be a giveaway as to what I'm doing. I'd want it to be a secret. But the Lego box, it is super heavy and super huge. So the podcast, the interview I'm going to be on for that one is on Saturday on Valhalla Awaits. I think they do allow dual streaming on those Lego builds. I'll check and see if they'd prefer that I just be on their channel or if I also air it on my channel. But we'll do whatever they want. A lot of pieces. A very, 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 very many pieces. It's huge. I could give you the weight of it, but it feels like about 15 pounds. You have time to order something smaller, something like a little kid set with like a little guy and a motorcycle. That's what I need to do. So I don't remember what the actual email was that came out. It sounds like it was in a court filing. And I realize, yeah, it's wrong to, if the judge says to file everything under seal and you don't, that's a problem. It's not quite the same as going out on national news and announcing the information to the mainstream media. But he did say there was something on Court TV as well, an interview where he and Karen Reed were on there. What blew me away is he gets up there, he's filing this motion asking for sanctions. The judge says, "Show me the receipts." And he says, "I'll get those to you." Where are your receipts?
Thank you, Your Honor.
Here we go, buckle up.
Your Honor, as I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him, and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate, and I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
No.
I didn't. I do have concerns about my ongoing obligations, so perhaps I could have a moment sidebar.
Sure.
So many sidebars. Did he throw himself on the sword? Couple things on this filing. It was AJ's name that was listed at the top one. Normally, the top name is the person who makes the filing, And Mr. Yannetti comes up and says, hey, that was me, actually. I'm the one who did this. I used an old template that had his name on the top. Not sure why he would have a template with somebody else's name on the top, but that's what he used. And he's saying, I made a mistake. It was all me, right? I kept the juvenile's name out. I used initials instead of using the full name. I tried to comply. It was oversight on my part. I made a mistake. The intent was not to disobey the court's ruling. This is basically as much a hat-in-hand apology as you'll see from a lawyer, and it was all done properly. It was like, here's what happened, here's how it happened, here's why it happened. I apologize. It was a mistake. I did not mean for it to happen, and I realized that the judge, in that discretion term, you can rule on it, but in doing that, just consider that this was not a willful mistake on my part, and the mistake that was made, the impact is rather small, if any. This last one, the revealing of grand jury testimony, that might be different. This is a separate argument, so we're gonna see how this plays out, and if it's going to play out in front of us, because sometimes you have to make arguments about things that are still under impoundment, right? And talking about them in open court would blow the lid off that topic. So they're dancing around this grand jury thing. We'll see what happens. Let's see. It was me, not Shaggy. A little suspicious. I don't think the KR is guilty based on what we've learned from this first trial. If the Commonwealth had not engaged in so much, Allison, I think that's an EDB term. Flakery? Is it flakery? Yeah, you got to type on that. Flakery. Then I may have thought differently. There's so much that goes into these pleadings. There's a ton of copy and paste. He took one for the team. I think he did. Yeah, it would have been bad for AJ if this fell squarely on his shoulders, because he's the guest here, right? He's the attorney who's been brought in from outside, from California, and given special permission to practice law in this courtroom, in this case specifically. He does not have a bar license from the Commonwealth. This is not his area of practice normally, as far as localities go. So he is here at the will and pleasure of the judge. She's the one that granted that, and she can reject it. We've got half an OnlyFan. Maybe we'll have to listen to some OnlyFans music while we wait here. Just one second. Let's see. Oops. We'll listen to OnlyFan while we wait for the judge to come back. Here we go. Ready on 3. We'll cut it off as soon as they come back.
Old man Joe just turned 74. Found a website, thought it was for more. Sharing stories about his younger days. Cooking breakfast in his own kind of ways. Signed up quick, put his pictures on. Fishing trips and mowing the lawn. Didn't know what it was all about. Just sharing life with no second doubts. Grandpa's OnlyFans, spreading love worldwide. Folks tuning in can't put their phones aside. He's gone viral, making money with grace, unaware he's in a different space. Neighbors whisper what they say ain't kind, but Joe keeps on. he don't seem to mind. He's buying tractors, fixing up his place with the earnings from his newfound fame. He reads their comments, laughs out loud. Grandpa Joe, you make us proud. Still oblivious to the site's true start, sharing his life straight from the heart.
There we go. We're going to end it right there. A little bit of OnlyFan music for you now that we had the OnlyFan on the screen. All right, we have. I want to hear this argument. I think it's going to be a juicy one, especially if it's argued openly in court, which could reveal a few things. Yesterday we were talking. We were talking on the channel about ASMR, because we had some ASMR moments, and I have to admit I did a recording last night, and it will not be on this channel. It will not be on this channel. It's a sleep stream. It's like a short story set to music, just to listen to help you drift off into another world of sleep. And I'm not sure if I'm ever going to release it, but I recorded it last night, so we'll see. All right, I'm going to give you some hints on my on the Lego design, because the podcast is coming up quickly where I'm going to be building this. I will say that the Lego set I got has over 1,000 pieces in it, and it weighs like between 3 and 5 pounds. That's a lot of Legos. Turn this down. We've got to crank the audio in this courtroom so badly because the feed comes in so quiet. But miss hearing the ghost wind. Sloth Life is Scottish, from Scotland. Sloth Life sent me my letter opener. Nice little Scottish blade, as well as another one that's a Damascus blade that is I'm not going to use to open letters. It's beautiful. This is a fun letter opener. Can't tease us like that.
All right, to the court, please.
We're back. Here we go. $10 minutes? Oh my goodness. The judge just said 10 minutes. It was all rise, she's leaving again. We've had 4 breaks so far. And we're almost to lunch. Oman-Ra or Oman-Ra. I like to do what I can to make the audio as good as I can. It's all this fun stuff that makes it possible. Software is sort of limited sometimes, and some of the hardware gets a little more flexibility, so I can boost audio and clean it up and everything else. Are you doing your Lego on your Thursday podcast? No, Big Old Micah, we're going to be on the regular podcast on Thursday, as long as the Weather Watch gets feeling better. I think he's under the weather right now. But as long as he's feeling better, regular podcast on Thursday. Then our the podcast that we do the Legos on is actually Saturday night. I think it's at 9 p.m. Is the judge okay? The judge is all right. I think the issue is they're dealing with a topic that's sensitive. Keep the fan going in the background. Should count the breaks. I think it's 4 so far. Lunch is like almost end of day for the judge. Laura says, how do I get to the songs playlist? I think I could twist one of the arms of the moderators and they'll post the Suno link. Here's the link for the collaborative live stream with Valhalla Awaits. See if Amber's able to get it, or Josh or somebody. Your gift is in transit. It left Gastonia, North Carolina at 4:26 a.m. Hopefully you have it tomorrow. Sloth Life, thank you. Thank you, thank you. Sergeant Fanning was the supervisor of Proctor and in charge of the jury. His name was disclosed by the Commonwealth, not by the defense motion. There was a little reference to that we heard from the Commonwealth today in their argument, where they said, we realize there have been problems before, but now this is like the last straw. And I think that was his way of saying, yeah, I know we were guilty previously, right? I know we screwed up as well, but this is the problem. And in thinking about it, I don't like the idea of there being a gag order on a case. Yes, I think it's very important to have a jury that's impartial, that has not been tainted by whatever news and stories and spin has been put on a case out there in the media. That's important. But a full-on gag order, I just don't like. So much happens under a gag order, under silence. You can't see until it's too late. Amber and Josh both provide the playlist link. There it is. Got some good songs on there. Let me know which one's your favorite. Virginia, you've got to go to the wedding. I think Fanning was involved in the Birchmore case in some way. I don't remember what the connection was. How can you put a gag order in a case that's out there like this one? Virginia, it really wouldn't affect anything pre-trial. I mean, you'd get a month of no talking, okay? But most of the work has been done. Most of the documents have been filed. There will be probably, I don't know, a dozen or so more, maybe 20 or so documents that are going to be filed between here and when the trial starts. If the judge does the full sanction and says everything is filed, automatically impounded, and then released by the court when and if deemed appropriate, that would just slow down information to us, and there would be some redactions, probably not a ton. There's not a lot that have been redacted. But it would just slow it down for us. During trial, once it begins, it would gag them. They wouldn't be able to talk to anybody, and that would be the big loss, as you wouldn't be able to get a play-by-play. How are things going? What's your theory? How's the defense doing? What's the mood on the team? What's the schedule look like? You would just get none of that unless it came out in court. Yeah, the gag order right at the beginning of trial, it's not going to do a lot. Isn't NDAs like a gag order? It's a non-disclosure agreement. How on earth would they find a new jury that doesn't already know about this case at this point? Amber, I'm glad it's not my job to do that. Hey, we have a prank call. Hang on.
Call from Selena.
Oh, it's not a prank
To
call.
accept, press 1. To send a voicemail.
Selena, I thought you were a prank call because of the area code you were calling from. But Selena, how are you doing? How are you feeling?
Well, I'm in a lot of pain. I'm just calling to tell you about it's actually funny now, the fall. It wasn't at the time, but
yeah.
I have a house with like many stairs. So I'm heading back down to watch the court we were watching, and my prosthetic foot got caught underneath my second stair. And so literally I flew through the air. I kid you not. I landed almost halfway through my family room and I hit my head and my face first. But I'm not sure what happened. I'm assuming that somehow my knee got twisted because my foot was stuck. I don't even know.
You tore your MCL. You had a big old
Yes.
bruise on your face. Your phone
Oh
broke.
yeah, they did it. They did a CT scan to check my head, but I have a hard head, so it was okay.
That's when that attribute comes in useful. Well, we are glad that it wasn't worse, and we're thinking of you. Hopefully, get a quick recovery and get that pain gone. But
Oh, and I have to just say thank you again, because I'm laying on my floor on my back with my foot up, with like going, should I call? And everyone's like, call 911. We're going to call for you if you don't call. So I have to say thank you again for giving me, the direction to call. But this one other funny part of the story is I was talking to my sister on the phone when I fell, and we were having quite a heated political discussion. And so when I fell and the phone flew, she was yelling my name, but I couldn't get over to her. She thought I'd had a heart attack because I was so worked up.
Oh my goodness.
Anyway.
Well, Selena, I thank you for checking in. I
will keep you posted. I love chat. You have been so kind.
We've never had as many applicants to our Facebook page as when I said you had posted the firefighter picture on Facebook. It exploded. There were people just coming out of the woodworks trying to join Facebook. I think they were creating accounts to see it. So that was
well, yay for your Facebook. I mean, all I could see through my pain was his sleeve, and it was nice. And there were several that had tats, but he had the most, and he put my IV in and the ambulance and everything, and all I could do was stare at the work on his arm. So it was awesome. Good.
Thank you for sharing
when I
that
took
with
his picture, I think he was offended a little bit though when I took his picture, because it gave me a strange look. So I'm like, maybe I shouldn't have done that.
Look, I bumped my head. Give me some grace. Come on.
Exactly. I have a brain injury. So
trying to document this for posterity and for all my friends. So.
Yeah, I have to share the tats with my fellow tat lovers. So anyway.
That's awesome.
With that, I will go.
Selena, you sound like you're in positive spirits, and I think that helps healing more than anything. So.
Oh my goodness, I'm so much better today than even yesterday. So, but Karen Reed always is entertaining. So.
Yeah. Thank you very much. It's good to hear from you.
Okay, thanks.
We'll see you.
Bye. Bye.
She called from an area code number that normally comes from scammers. So. We're getting more Facebook requests. Yay. If you do click the Facebook request button, do know that when you click to join, if you scroll down before you click to join, there are some questions on there. Answer them to the best of your abilities. The most important one is at the very end, but do answer all of them. That would be great. If you don't know, just say, I don't know, or what does this mean, or something like that. We use those questions to filter out the bots, because there are bots out there that want to join, and then they just start spamming useless junk that nobody has time for on Facebook. So help us by answering the questions. We'll get you admitted and get you in amongst your friends on the Facebook side. So a couple more minutes of break, and then I expect the judge to come back and say it's lunchtime. I don't know. Is that ceiling cracked? You guys seeing that? Looks like the ceiling is cracked and possibly water damaged. Might have some activity here in court right now. Let's take. Oh, you can't see it at all. I was the only one looking at it. A little bit of cracks there on the top, sort of right. Let's see where my hand is. Right up that direction. Just a little bit up and over. There's a crack in the top, and then over by the light as well. Looks like a light reflection. just to the right of the light. It's either water damage or a light reflection off a computer monitor or something. All right. It's the Matrix. The paint is a bit flaky. I'm not saying that that's an indicator of the court's performance, but why does Yannetti sound so humbled? Because he was caught with his pants down. No, not literally. He made a mistake, and he's owning up because it was a mistake, and it was bad. Anytime you disobey what the court says, that's bad.
Court is back in session. You may be seated.
Judge is back. And we have another sidebar. Oh, my goodness. We're in the Twilight Zone. We have some really good trials coming up. We have some great ones. Obviously, Karen Reed's going to be interesting as that goes forward, if it goes forward. We also have Corey Richins, the other KR trial, happening out in Utah. That's the fentanyl poisoning, husband poisoning. Brian Koberger is making some significant progress, and we're getting some interesting filings. They're giving us a peek into how we expect things to go in that case. It's all going to be under advisement. Mr. Yannetti, Barb, made a motion, basically a court filing that included information that was supposed to be filed under seal, and he didn't file it under seal. So you had to do something with Mr. Proctor, an email or something from Mr. Proctor about how Mr. Proctor felt about the rest of the defense team, which it should be not be a surprise to anybody who's watched any of this trial, but it is a violation, and the judge is going to rule on it. Let's see. Selena K gifted 5 memberships. Selena, thank you very much for your generosity. David Reed, Disco World Edgewitch, Ann Finke, Canadian Girl, and Lauren, all brand new green names, thanks to Selena K's generosity. If RA covers Karen Reed, it's going to cost the hubby a lot of cash. Oh, man. Camilla says she's going to make herself a Brazilian banana curry for lunch. I guess it's important to say Brazilian banana curry all in one. You can't just stop at Brazilian. Having heated delicious off-the-bone ribs for snackies. Reheated delicious. Let's see. Long sidebar. It's noon. I mean, the clock is striking noon right now. In 3, 2, 1, now. That was when it was noon at my. So you got about a 10-second delay for you guys, but Lori Vallow, man. I don't know. Lori Vallow has successfully got Court TV thrown out of her previous trial, and she might be successful in Arizona as well. It's going to be a train wreck with her being pro se. Is she still pro se? And she's a little bit, I would say, on the different side already, which is just going to be. I think it's going to be a frustrating trial, almost Darrell Brooks like. Arizona's a different game. Yeah, Idaho's, all entirely different, but she's already filed some motions objecting to Court TV coverage, which I think is the pool TV camera for that trial. Donna Adelson, I saw she was in the news complaining about she doesn't like court. She's been harassed for her commissary. Her son Colby Ryan has a channel where he shares his thoughts on the whole situation, and he's worth supporting. Disco World Edgewitch, welcome, first of all. Good to see you in green. Congratulations. Colby Ryan, tell me, where does he stand on Lori's position? Is he supporting Lori, or is he like an anti-Chad, pro-Lori, or anti-Chad, anti-Lori? Where does he fall? I'm curious, just overall. John, she's different. She's operating in a different world than most of us, I think. Not supporting it either, just providing the info. Let's see, Robert Brooks. Which one's Robert Brooks, Curtis? I have a hard time making a schedule more than a couple of weeks out, even tentatively. Just because, like we had this week, 2 of the trials that we were looking at following this week pled guilty or took a plea deal. One of them today. So it's hard to, all the best intentions go to waste with court because it just changes constantly. Anti-Lori and Chad, but not my cup of tea. He's anti-both. Jennifer, I saw that. I saw it said September, and I just put it on the back burner because that's way out, and that's going to be, man. Is that going to overlap with Koberger? Koberger's what, 12 to 20 weeks or something? It's going to be all summer. I'll take a look. I'll see if I can pop over there and listen to some stuff. Plea deal today was the case with the strangulation. It's like the high school or prom date strangulation. I forget. Took a plea.
All right, Mr. Unetti, go right ahead.
Thank you, Your Honor. And thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in...
Again, we did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge.
I just want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement, and what was the date that you all found out about what Mr. Brennan just announced in court?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe, perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court.
So that's a nothing.
So just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Okay. Any follow-up, Mr. Brennan?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
If I may just briefly respond, Judge.
That is the worst argument ever.
I'd like the court to take particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Court TV was not in the courtroom. Wow.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed.
Got a stack of these fiery ones.
And what I'd like to do, I have one that has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to...
This is going to be a fiery one, if it gets argued.
And the Commonwealth's opposition. I would like to hear that now. You need to give me a minute. The parties have any problem hearing that motion now? It is a...
No, Your Honor, I think it's very brief.
Brief but fiery.
So I need 1 minute, Mr. Jackson.
Mr. Jackson, first time he's up at bat today.
From this morning, the new ones.
Okay. The last we heard was that the federal investigation has been closed. We heard that in court today. The judge said that the information that Mr. Brennan revealed today was that the investigation has been closed.
I have to check. All right, so you're both prepared to argue this motion, right? The motion and the opposition?
I'm so sorry.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition. I just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger because...
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may
Can you make your
Yes.
comment? I want to hear the argument. I just don't want the state to buckle on this. Everyone's checking their calendars. How do you want to proceed?
May I address before Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G-I-A-M, P-I-E-T-R-O, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos, and then about another 15 actual videos. I basically...
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was...
Your Honor, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred in?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the table.
So what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just want to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that I have.
I have not looked at them. Attorney Lally did, and he represented that they're all the videos we've already turned over, same quality as we previously provided.
Okay.
They're just copies of the same videos, although I do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting them, we've passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do, I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sallyport video and related evidence, that has to be filed by Thursday with the idea that we will have a hearing on this on Friday. Okay. We have Friday already blocked off. This way here, you can all leave for today, and we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Ms. Gianetti after 5:30 on night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps
gonna
an
be
hour and
spicy.
20 minutes, something like that.
Okay.
Hour and 20 on a motion to dismiss the case.
Any idea?
Of argument time, Your Honor?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Oh, of course, yeah, yes, I believe we will, for sure.
How does that schedule work for people?
It works for the Commonwealth.
I need to ask this one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to
Thank
just
you.
go do that
Thank you.
and not have to come back here tomorrow.
Yeah.
And I'm trying to consolidate
You're in
this
federal
out so
court,
we can
what?
Even a half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight by the time we get done, and I can get to the airport. That's fine.
Why are they in federal court
So
tomorrow?
where do we stand on the motion for reconsideration? It sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that. Obviously, we gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the KMPD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion was just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay.
We're going to be a couple of days.
Okay.
And we have motions on maybe Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite a bit of our prep time.
All right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back Monday.
We can do that then.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions in limine due on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss though, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not be anything at all. I won't know until I have a chance to actually go through everything.
But I need time, right? I need to know that Thursday. It doesn't have to be a complete report.
He was drumming on the
An
table.
outline even, would the Commonwealth be satisfied with an outline? Know what the points are?
An outline of what you are.
Of what Ms. Little says, how this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I'll want to supplement it very quickly thereafter. I have to decide this and put something in writing. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute, Ms. Little?
Not sure what that noise was. Everyone just pretended it was normal. Maybe like a heat register or something kicking in.
Your Honor, given what Ms. Lee just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court, if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede the motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang-up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right. Ms. Little doesn't look thrilled.
Right. Her key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay. What's the Commonwealth's position?
I'll defer to the court. I know it's more complications for the defense and travel will be available whenever.
So I think we did block off today and tomorrow with the understanding that the defense team would not be here until sometime 11 o'clock or later. What about, Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on Friday...
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. And Ms. Little will handle it's her motion anyway.
I greatly want to accommodate the defense as we've had the entire time I've been here, but we have trial prep to do as well. In more court hearing days, we have hours of conversation, the more time we can meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hear that tomorrow as well?
Very well.
Okay, and then we'll just finish up everything tomorrow.
Very well.
All right. All right, and then you won't have to be here Friday, but the motions in limine are all filed. It also involves filling out a final trial conference report.
Understood.
So we need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're going to have a full hearing. I believe it's the 18th, and the motions in limine.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both, try and get everything done.
Should we file a formal motion to ask the court's permission for a delay from Friday till Monday?
For the...
Motions in limine.
The Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday? Or were they all on Friday?
Reciprocal discoveries due Thursday. We want that to happen. Motions in limine, I believe, are due Friday.
Ms. Little, would you like the weekend for all those motions in limine?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motions in limine to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the Daubert motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for?
Dr. Wolf, it's a neurologist. So there's
I
one
thought you
additional.
meant, I was thinking the archivist.
No, Your Honor. It's the neurologist of the Commonwealth. Wolf without an E. WOLF. That was filed 2 weeks ago, I think.
I have not seen that.
Okay.
Well, print it out.
I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their Lanigan motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right. If you get
Tomorrow's
word
gonna be
that you'll be
spicy.
leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure, okay.
Anything else for today then?
Not for the defense, Your Honor. Thank you.
So I'm gonna give you all why don't you fill up all the percent of the application?
Point of court, all right, please.
Did she just throw a temper tantrum? What did she just say? There we go. There we go. I want to see what she just said. I don't know. Sorry. Back up a little bit. Okay, we're going to mark that in. Run that to my timeline. I've got to remove some of the noise from the courtroom. Hold tight. And she gets up and she walks away. Dump that down. Okay, and now fix the audio. So just 1 second. Here we go. We're going to go right here. Let me just fix the audio really quickly and take some of the background noise out. Isolate the voices. Okay, let's listen carefully here.
So I'm gonna give you all why don't you fill up all the percent of the application?
Point of court, all right, please.
What? Do you guys hear that? Let me crank it up.
So I'm gonna give you all why don't you fill up all the percent of the application?
Point of court.
That did not sound like English. I heard the so and I. Why don't you all? Yeah, that's what I got. Why don't you all just huddle? Why don't you all? Yeah, that's all I got. All right. She's done. She's done. All right, we're going to be done with Karen Reed for the day. I think they're done for the day. Tomorrow is going to be the spicy. I thought it was going to come in today. Tomorrow is going to be the spicy argument. The motion to dismiss is the big one. The motion to dismiss. This is the defense coming in saying, Your Honor, the Commonwealth producing videos that they promised they already turned over or did not have after the trial was over is a bridge too far. We cannot restore that, back to Karen Reed. She's already lost that. She will never get a fair trial now because of that. She said she'll be back in 10 minutes. I think she said, why don't you all go to lunch? If she does come back to lunch, come back in 10 minutes. We'll cover it after lunch. How about that? All right, Corey Hill. How how 14 months comes and goes. It's pretty quick, huh? Corey, I like your camera. Is that what kind of camera is that? Saw that in your profile picture. Congratulations, Corey, on 14 months as well. It's a D850 Nikon. That's awesome. I've never shot on a Nikon. I've shot on Canons. I've shot on Sonys. I've got a good friend who's a photographer who swears by Nikon. Absolutely loves it. But Patricia says, I love Alan Jackson, the singer. Does at least sound like the videos they handed over yesterday are the same ones they handed over before. Teresa, that's what I heard. It sounded like we handed everything over again just to make sure you had it all. But I think there's some other ones that were new, and that's where the problem comes in. So I've got to run to the post office box. We've got some cool stuff to pick up. Thank you, Kim. Appreciate that. Every time it's been a while since I've super chatted, I've noticed you appreciate the camera profile pic. I love cameras, Corey. I love tech. Here's what's happening in in Karen Reed coming up. Today was the motion hearing. Tomorrow there's a double jeopardy hearing, and Amber, by the way, thanks for this. A double jeopardy hearing in federal court for Karen Reed. Then on Wednesday, we just heard the schedule for another motion hearing, including that motion to dismiss, which is going to be the big one. Then I think Turtle Boy has a motion to dismiss on Wednesday as well. And then Friday, there's currently scheduled for a hearing. Might not happen if they get everything done on a Wednesday, and then they'd be back in court on Monday. starting to argue some of the motions in limine and everything else. All right. What was the conclusion from the federal investigation? I can tell you, also thanks to Amber, we have a letter here. Let me read this. This is from the Canton Police Department, so take it as face value. To all media outlets from Helena Rafferty, Chief of Police, date March 4th, that's today, 2025, regarding federal investigation. Here's the letter. It says, and I quote, I recently spoke to and was informed by the U.S. Attorney's Office that all aspects of the federal investigation initiated by her predecessor and related to the death of John O'Keefe have been completed. The investigation is no longer active and will be closed. Due to ethical limitations, I cannot comment further. End of release. So that is that's the latest and greatest. Looks like all federal investigation into the death is over, and apparently there are no charges. So, motion in Lemonade comes up next week. Heard this last week. Yeah, I think it was just confirming it through Canton Police. So. Time to play the music. It is time for lunch. We're going to come back, probably do some court hopping. We've got a little case out of Thurston, Washington, which we might look at the motions in limine for that one. Josh has alerted us to that. The trial happens, I think, on the 17th or 18th. So it's a ways out, but we might take a look at that and see if it's a case we want to follow. Always in Thurston. It's one of our favorites. We love it. Who is the Miss Little in the Canton court? Is she the one that's going to federal court tomorrow? I think all of the defense team for Karen Reed will be in federal court arguing for the double jeopardy issue. And yes, that is her. That's the female attorney on Karen Reed's team. Thurston is always fun. We will be court hopping when we come back. I have not made a portal yet, so you'll have to click the subscribe button and ring the bell so you're notified when we go live. Kathy says, I was declined to join Facebook. Kathy, did you answer the questions? It's very important. You have to answer the questions. It's the only way we can keep bots out. But all you have to do is go back and apply again. But before you click join or request to join, make sure you scroll down and answer those 4 questions. And then apply again. You'll be amazed how easy it is to get in. Bots are people too, says Greeners. Yeah, but we don't want them. Sorry. All right. Is there a portal? No portal yet. I'm going to run to the post office. I'm going to figure out what to do with these Legos. I'm worried I have to get a new set. This is huge. It's crazy. And answer the questions. That's all. Answer the questions. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again after lunch. We'll see you after there.